Item number 6, Commissioners, is a resolution, and we heard public comment time about this particular issue. As you collect your thoughts on what you want to do with this, let me just point out, and certainly we'll get a motion on the table and then have some discussion. I think that everyone should know that when this law was enacted, which was a typical unfunded mandate, by the way, that the law was written and specifically intended for the purpose, the sole purpose of keeping a verbatim record for a certain period of time for in the event that someone felt that a public body went into closed session for a reason that would violate the Open Meetings Act, that they could petition the court and ask a judge to review those minutes, whether it's audio or video, in camera. That's the way the law reads, which means an inspection in the judge's chambers, where the judge would then make a determination as to whether or not there was a violation of the Open Meetings Act. We are required by law to maintain written minutes of both regular open meetings and closed meetings. And we will forever have the record, you know, for people to read throughout the entire United States. From our closed meeting minutes, we may not, depending upon whatever action you want to take tonight, we may not just have the audio recordings. I think that this recommendation has come to us because the clerk of the village, in this case it's Clerk Moritz, but the clerks of the future have a job to do as a clerk dealing with records and record retention. So for instance, you know, these are not the only, you know, what you have before you tonight is a proposed recommendation to be able to destroy these records. The clerk routinely destroys written records, not minutes, but paperwork. We accumulate in this paperless society that we live in just a tremendous amount of paper, and in fact, had the prior and current clerk not gone through the lawful requirements of disposing of those records, we would need another building this size to house them all in. And so this is kind of both an operational and an administrative tool, because if they're not disposed of, they've got to be archived, they've got to be kept someplace, they've got to be preserved so they don't get damaged. We have the written you know, accounting of discussions that are taking place in closed session, and so that's why this is before you tonight. What's your pleasure?
Motion to approve, Your Honor.
We have a motion to approve by Hosty. Is there a second?
Second.
Second by Commissioner Curry. Discussion.
Mayor.
Commissioner Tellalian.
I guess fundamental reason I see for maintaining these tapes at this time is the fact that there are so many issues that are before this council that were also discussed by the past council. Certainly the YMCA, some other issues that have a life greater than a year and a half or 18 months. All the minutes in question or tapes in question are related to the previous council. And I don't know, I guess I'll ask the question either to the clerk. Are these all the closed session tapes of this period of time, or are there others that we are maintaining that are not included in this list?
There is one sediment of, there's one tape that I took off the list because there are no minutes, but that was from before I was here, and
Okay.
I don't have the minutes.
So fundamentally, I think that we've got issues before us that it may prove beneficial for us to have those tapes. Certainly the YMCA is an ongoing issue that's been around for a long time. There's other issues. So I think just from a an operational standpoint, we should maintain these minutes, or these tapes. The other thing too, you know, I've made this statement a number of times regarding the minutes themselves and how the discussion is very, I believe, is very minimal, and the detail is very minimal, so that really I don't think the minutes capture the discussion in an adequate way for those to be of any real value in the event that we would have to go back and look at these minutes. You know, I think we barely meet the requirements of the Open Meetings Act with our minutes, and I've made this statement before. I've let it go because I can't rail against it forever, but I think that our minutes are inadequate for if we ever to need to look at them before. Again, I'm sorry, and I think most importantly, there's no reason to destroy these tapes. If anything, we should be looking at these tapes and identifying those items that we should be omitting and destroying and releasing the remainder of them. You know, fundamentally, it's the village, the people's right to know. Their right to know what business is being conducted by the village. So that unless it's a privacy issue or a something that would do any harm to the village, it's very clear in the Open Meetings Act, there's no reason for us to destroy these tapes. In fact, we should be issuing them when there is not harm being done to the village or privacy being violated. So I'm going to be voting no, or will entertain any other thoughts that the other commissioners have on this.
Okay. Further discussion.
Mayor,
Commissioner Curry?
there's a few issues on the tapes that I think might need to come up for review. Therefore, I would hope the other commissioners might be inclined to, I'm not going to make a motion to table yet until they give their thoughts, but then afterwards I anticipate making a motion to table this item. Unless the other commissioners don't want to speak, and then I'll make a motion to table it.
Okay, is there any other discussion?
I guess it's a technicality, Mayor. If we were to say no, this comes for us every 6 months. We're asked to review closed session minutes to see if they should remain closed. I didn't see anything in the Open Meeting Act that would bring this forward at any particular time. I'm sure that it could be brought forward at any other time. So that is tabling the same thing as essentially is at this time voting no. It would seem to be to me, but maybe that's, I don't know if our village administrator or attorney wants to comment on that. I don't think there's any, I think that they can be brought forward any time. If we say no now, in the future they can be brought before us again. Or if we table now, in the future they can be brought before us again. Is that correct?
Well, a table is a table, it's not a no. You know, a table just defers action.
Mayor,
Commissioner Curry?
I'd like to make a motion to table this item.
Okay. A motion to table takes precedence. Is there a second to that motion?
Second, Your Honor.
All right, and we have a second. There is no discussion on a motion to table. The clerk is prepared. We'll call the roll.
Commissioner Hoskins?
No.
Commissioner Curry?
Aye.
Commissioner Hosty?
No.
Commissioner Tellalian?
Aye.
Mayor Calderon?
No. The motion to table fails. So we're back on the main motion. And I'll go back for discussion.
Mayor,
Commissioner Hoskins.
while I've certainly never listened to the tapes in question, going back to 2005 and through September of 2006, I've heard varying accounts of things that were said. I think that in several instances, unfortunately, former commissioners sometimes lost sense of decorum and said some things due to fatigue, due to hunger, due to impatience with different opinions that I'm quite certain they probably would not say in an open forum. I think some of those things are disgraceful, and I think it's better that they're not reflected verbatim. I think in most cases the minutes do catch the spirit of discussion. Since I've been on this council, I've been in a number of closed session meetings where I have witnessed a loss of decorum, and I think people say things when they lose their tempers. that really, there's no benefit to having those things out there. I'm not for book burning, I'm not for suppression of information, but I think there are certain things that make our village look good, and there are certain things that don't make our village look good. And quite frankly, down the line, I hope that some of our closed session meetings are not reflected verbatim, because I think things are said in error, some off-the-wall ideas are proposed, and they wouldn't do too much but embarrass people and hurt feelings if they were put out there. So, you know, with all due respect to what was said in public comment, I am prepared to support this motion.
Any further discussion?
Mayor.
Commissioner Tellalian.
You know what? I think it's important that we look at this from the other side, from a different side, and not that there are certainly things that that would either harm the village or be an invasion of privacy that should be gleaned from these tapes when they're eventually released. But I think we should be looking at it from the standpoint of, you know, fundamentally, and the first line of the Open Meetings Act ends with the people have a right to be informed as to the conduct of their business. This is their business. When we're in closed session or we're out here, this is their business, and they have a right to be informed as to the conduct of their business. We don't want to invade people's privacy. We don't want to damage the village's position with regard to any negotiations or personnel issues. We have very clear guidelines for closed sessions, but we should be going through these minutes and looking to say, okay, this remains. This part should be destroyed. This part is not appropriate to send out, and the rest should be released. And I agree. We've had our moments as well, but you know, maybe if we were aware that we're doing the people's business and they've got a right to see us in action, then, you know, we might all conduct ourselves in a better fashion. You know, I think it's really important that we keep these minutes, especially with the fact that there are so many issues that remain outstanding. And you know, it may come up that we need to look at these things for the YMCA or any other issue. It's too new. You know, 18 months is the minimum that we're required to keep these. Some of these are just over 2 years old. So I hope my fellow commissioners and mayor will go along with this and recognize that this time it's not appropriate for us to destroy these tapes.
Yeah, we have a large audience here tonight, and certainly it would be unfair also for them to maybe perhaps walk away and not fully understand the chain of events that have taken place, and also this whole thing called the Open Meetings Act. And certainly, you know, prior to 2005, before the Open Meetings Act was amended, prior to 2005, there was no opportunity at all, for members of the public, just like the ones out here, to be able to see the people's business in closed session, because they don't exercise that, they don't possess that right by law. They didn't possess it prior to 2005, and they still don't possess it today in 2008. Commissioner, what the Open Meetings Act says in the opening statement, and it speaks on point to one of the reasons that public bodies such as us are not allowed to make decisions in closed session, meaning when we go into closed session, we cannot take any official votes. And we've had plenty enough closed sessions for all of us to know that. And the reason for not being able to take a vote is to speak specifically, Commissioner, to whatever, if it's in that first paragraph, because we have to take those votes out in public so that the people can see how we are conducting business and the actions that we're taking. I don't believe for 1 minute that law is intended to give anyone the opportunity, if, as Commissioner Hoskins pointed out, and over the years I'm positive that it has happened, under duress, under stress. I know I've been sworn at a couple of times You know, what good, what public good, what public purpose could possibly be served if the members of the public heard, not any of the commissioners currently sitting here today, but listening to one of those voices swearing at me? I'm curious to know what public good is served by that. Please share it with me.
No, it certainly would be entertaining. I don't know if it'd be certainly public good.
But
And there
that's
might
my
be some
point.
people that would agree with it, but that doesn't mean, you know, that the Lisa Madigan issued that has a guidelines for the open meeting magazines, guidelines for the sunshine laws. Now, and I know that we don't agree with that. We don't follow those, because in there it says that the minutes should reflect the nature of the discussions, and someone reading the minutes should be able to understand the positions of the people that were, and the reasons for their vote. We don't do that. Our minutes don't do that. You know, and action is one thing, but it's more, our public business is more than just actions. Public business is the act of debate and the act of discussion. And they have a right to know where we are, what our thinking is, and how we reach our decisions. And it's more than just actions. And you're you know, certainly you're right, we can't take action in closed session, but it's more than that. We should not be destroying these tapes.
Any item that comes on our agenda, and of course it depends upon whether or not we adjourn or recess in the closed session, every elected official absolutely positively has an opportunity, after a motion is made and seconded, duly seconded, and when we get to this thing called discussion, every elected official absolutely has an opportunity to voice, just like we're doing now, why you may have formulated an opinion that you have made. And you could be re-emphasizing a conversation that you may have made during a closed session, but doing it out here in the open in front of the public. Every one of you have that opportunity. I think this notion, there's no doubt in my mind, this notion of, you know, needing to maintain these things, not by any of you commissioners sitting up here, you know, I think tends to get thrust in the public's light based upon sinister motives, thinking that something sneaky has taken place, when clearly it's impossible, because we cannot take any action in closed session. We have to do it out in open session for the people to see, and they can see how everyone votes. Every elected official has an opportunity to say why they're going to vote in favor or vote against it, if you choose to, so that the members of the public can understand why you're taking a position that you've taken. But for the public, you know, to listen to some of these conversations that may pertain to, you know, trying to establish a price on property or dealing with a disciplinary matter with an employee, I'm trying to allow any one of you to convince me how the public is best served by hearing that verbatim conversation.
I'll put it a different way, Mayor. How are they ill-served? How are they ill-served by that? Once there are no longer any confidentiality issues or privacy issues, how are they ill-served by hearing what was said?
Sure.
And in terms of our actions taken, we're not entirely free to discuss everything that we discuss in closed session when we come out to take an action. There are many things that would remain confidential that, in terms of the position, whether it's an employee issue or the village's negotiating position, and we shouldn't be. We're not free to divulge everything associated with our decisions when we come out of closed session and take action. So,
Because you can,
again, how are they ill-served by releasing that information?
members of the public could take those tapes and cut and paste those, and most likely they could be used for political purposes. And most likely that's what they would be used for.
Mayor,
Commissioner Curry?
those tapes are great for attorneys in litigation purposes also.
You know, it just, you know, if the legislature thought that it was important to preserve these tapes, you know, they could have amended the Open Meetings Act to simply say, you've got to keep these, you have to do a verbatim record, and you got to hang on to them. They didn't need to go to the extent to say, well, you got to hang on to them, but really it's for an in-camera inspection. And I think the reason that this came before the legislature is because somebody, you know, somebody pitched the beef, not here, but somewhere in the state, somebody said, we think that members of the governing body are going into closed session in violation of the Open Meetings Act. So meaning they went into closed session saying that they're going to talk about disciplinary matters, and they talked about something else. They didn't discuss topics that are allowable to be discussed in closed session. That's why the law was amended, to allow a judge then to make a decision, to make a determination if he thought, he or she, meaning a judge, thought that that governing body was violating the Open Meetings Act. That was the intent of the law. And now we're trying to come up with our own intents of the law. And you know, Lisa Madigan's opinion, I don't believe speaks to this particular issue of these verbatim records. That's a general opinion by the Attorney General about the Open Meetings Act in total. But of course, sometimes the Attorney General should practice what they preach too. It's real easy to say what all of us should do. But then sometimes, including the Attorney General, they don't like to practice what they preach. And I think that's a little unfair.
Mayor, we've had a lengthy discussion. Just so everyone here is clear and those watching on television at a future date, can you please make certain that everyone knows that there is a written record of what was said during the meeting, closed meetings, as well as can you explain how easy the process is, or the process of obtaining a copy of that written record if necessary?
For those records, whether they're regular meeting minutes or closed session meeting minutes, and in particular for closed session meeting minutes, after we have approved those to not remain closed anymore, then a simple freedom of information request is all that is necessary by any member of the public here filed with the village clerk, and that member of the public can get a copy of those closed session meeting minutes. And in fact, once our minutes are approved, you know, and I know we heard earlier tonight about the whole transparency in government thing. You know, we have all of our minutes. Not only, you know, you can file an FOI request, or you can go right to www.forestpark.net without the hassle of coming in here to Village Hall, and you can look at our meeting minutes. They're all online. You can look at our village council meetings. That we have the videos of our council meetings posted on our website. So, you know, I don't know how much more transparent you get than that. We post it all out there. Nobody's hiding anything from anybody. We certainly capture, I believe we capture the essence of the conversations that are held even in closed session. The same way that, because we've had the dialogue on our regular meeting minutes, even ones that we approved tonight. They're not verbatim. They're intended to capture the essence of the actions that you took. You know, what was basically discussed and what were the actions that you took. You know, to hear somebody that may temporarily get volatile with another person or say things that, you know, they may have regretted saying, I don't believe that those really have a place in meeting minutes here, because it has nothing to do with the action that was taken. I mean, action taken is action taken, and that's done typically by vote.
So it's a very simple, easy process for the concerned citizen to receive a copy of what occurred, correct?
Once meeting minutes are released, approved and released, I mean, absent, you know, driving meeting minutes to somebody's house, I think that they are very, very easy to, you know, to get a copy of. Very easy. Now, I don't believe there's ever been any intent to withhold any of those meeting minutes from anybody.
Mayor?
Commissioner?
No, they are easy to access and go online and read. But there has been a drastic decrease in the level of detail that's been placed in our minutes in these last year and a half, or since we've been on council essentially, since some things came out last year ago summer. The detail's gone down, and as a little quiz or a little test for people that have seen some other contentious issues like this one, after you get done with this meeting, you see how, the discourse, read what's in the minutes in 7 days when they're posted, and then you decide how much detail and how much information is being presented and whether those minutes reflect discussions that we had. I'm pretty sure it's going to be, there were discussions and the clerk called the roll and this was the vote. So take a look for yourselves. Do you think it's open government? You think that the minutes that we are preparing now captures the essence of what's going on at this council? Then you're happy with your level of the open government they're having. If you don't think that the minutes are enough, then you know, stress to us that you want to see more.
Okay, any further discussion? Hearing none, then I'm going to ask the clerk to call the roll on the main motion, and the main motion was for adoption of agenda item number 6, correct?
Correct. Commissioner Hoskins?
Aye.
Commissioner Curry?
Aye.
Commissioner Hosty?
Aye.
Commissioner Tellalian?
No.
Mayor Calderon?
Aye.
It's resolution R 6508.